Thank you very much, Senator Okongo Mogeni, Senior Counsel. I had prepared an elaborate presentation that was going to last about 2 hours, but realizing the paucity of time that is available to us, I propose to speak for a lot less, possibly 10 to 15 minutes. So I will not be going through standing order by standing order. I propose just to interest you, particularly the new standing orders, into the mysteries of the standing orders and what lies in there. So I'll just speak to the various chapters and what you expect to find in there and the importance of the various chapters of the standing orders. In the last session, one of the presenters spoke about the 3 habits of highly effective, I believe, people or people who engage with the media or senators. In this one, I just want to give you one habit of highly effective senators. That one habit is familiarity with standing orders. There is probably no other way. What do the following legislators, the following legends in legislative work have in common? Just to name a few: Martin Shikuku, George Haniri, James Orengo, Boni Halwale, Moses Wetangula, Kipchumba Murkomen. The list is long, but these are people who have distinguished themselves, and I think their secret is their familiarity with standing orders. Let me begin with one anecdote. I used to style myself as a desk officer for former parliamentarians, a purely honorary position. So they would come to my office, and I found it very interesting engaging with some of them. And before his demise, I asked Martin Shikuku this story about the day he challenged the Honorable George Saitoti and what that was all about. And he said, yes, I did. I asked him, so what happened exactly? He said he was very cross with the front bench. And on this one occasion, he said, you know, some of these people from the front bench, they don't know anything about the standing orders. They just come here, they don't do their work, they don't do their homework, they are let down to the legislature. And Honorable Saitoti here, leader of government business, doesn't know the first thing about the standing orders. In fact, I want to challenge him. If he knows what standing order number 1 says, I will resign. And he didn't resign. I think the long and short is he never resigned. So I want to challenge him. Can he tell us, Mr. Speaker, what the standing order number 1 says? So I asked him how he could take such a risk and whether he was going to have resigned. And he said, you know, I had made sure that there was no standing order around where, before daring him, I had made sure there was none around. So standing order number 1, you need to know standing order number 1. It is a standing order, a default standing order, which allows continuity and which allows the House never to stall. Because in any matter that is not specifically provided for, we find recourse in standing order number 1, allowing the Speaker to decide any procedural question where we don't have other provision. And the Speaker is supposed to be guided by the Constitution, statute law, usages, forms, precedents, customs, procedures and traditions of the Parliament of Kenya, and other jurisdictions to the extent that these are applicable. So if you remember, no other standing order number 1 is very important because it has been invoked a lot of times when we run into difficulties when it doesn't appear that there is provision. But let's first find anchor of the standing orders. The authority for the standing orders is in Article 124 of the Constitution, which provides that each House of Parliament may establish committees and shall make standing orders for the orderly conduct of its proceedings and the proceedings of its committees. So the standing orders are firmly located and anchored in the Constitution. And the Constitution also provides at Article 117 that Parliament may, for the purpose of the orderly and effective discharge of its business, provide for the powers, privileges, immunities of Parliament, its committees, the leader of the majority party, the leader of the minority party, the chairpersons of committees, and members. So that's just important to locate the standing orders. They have constitutional basis. One of the questions that sometimes asked is where they rank, say, vis-a-vis legislation. If you were to find that the standing orders are in contravention or they are not in sync with statutory provision, what the correct hierarchy would be. The standing orders are the rules the House has set for itself for the discharge of its business. Part 1 of the standing orders is important. Please take time to look at the various definitions. There are a lot of things you can find in Part 1. What is a parliamentary party? What does it mean when something can only be done by leave of the Senate? What are the presence of Parliament? What is a sitting day? Please find time to look through the definitions, because only then can you locate the various terms that are used in the standing orders. Part 2, the swearing in of senators, we just went through that. Part 3, the procedure for the election of the Speaker and the Deputy Speaker, we just went through that. We probably won't go through it again until another 5 years, but it's useful to look through the requirement that every senator must be sworn before they commence the business and all that. Part 4, who presides in the Senate, presiding in the Senate, and also the resignation and procedure for removal of a Speaker and Deputy Speaker. This is the first time we have put this in the standing orders. The previous time we had not had provision for that. The Presidium, Part 5, presiding in the Senate, who presides, and members of the Speaker's panel. Of course, the Speaker presides in committees. Usually it will be the chairperson of committees, that would be the Deputy Speaker or the members of the panel. Part 6, the political leadership of the Senate majority and minority leaders and their deputies, how they are determined based on party strength, who initiates the correspondence. In fact, right now we are running through that. We are expecting correspondence for the majority and minority sides, telling us who their leadership are, who's the minority leader, who's the majority leader, who are their whips. And the way that is done is under Part 6. Part 7, which we will shortly next week experience, addressed by the President or a visiting dignitary. How do we get to the place where the President comes to address, and a joint sitting that will be addressed by the President when we open? What happens? We stand to order, we don't clap, we don't applaud, we listen to the President in silence. Thereafter, we retire to the two houses to discuss the President's speech for up to 3 days, and then after we continue with our business. Also provision for visiting dignitaries. The Senate has had visiting dignitaries. Both the Senate and the Assembly has had visiting dignitaries address the houses. Part 8, the calendar sittings and adjournments of the Senate. Very important. Legislators from the times of yore will remember that the Parliament never always had control of its calendar. Some of the things you can't take for granted. Now the Senate has full control of the calendar, and that's going to be determined by the Senate Business Committee. When it meets, we will give a draft, and so the Senate decides for itself when it will be in session, when it will be in recess, and ordinarily we will run every year. A session is a year. Every year we will ordinarily run from the second Tuesday of February to the first Thursday of December. Just to note, our sitting times are not the same as the National Assembly. We only sit afternoons. The Assembly sits morning and afternoon. On Wednesday, we sit only afternoons. We never sit mornings. We used to, but the Senate is in charge of its calendar. In times when we had older senators, they thought we shouldn't sit So, Speaker, I don't know whether this is going to change. The quorum of the Senate, Part 8, 15 senators required before we can begin business. It looks like a small number, but it poses a challenge sometimes. And we will not be beginning business until and unless we have 15 senators. So if the bell is rung and it's time to start, but we don't have 15 senators in the chamber, we will not be beginning business. We have reverted to this because it's a constitutional requirement. We had abandoned it, and it was up to a senator to raise it, but questions of the constitutionality of proceedings held without quorum arose, and now we require it. And we also require quorum before we can go to a vote or a division. Part 10, the order of business. There is no ambush in the legislature. We usually tell you what the business will be in the order paper. We'll put it out in the website. You will know in advance what the weekly program is. This is a requirement. This order paper, this business is determined by the Senate Business Committee. We sometimes are confronted by senators who are unhappy. Where is my bill? It's not on the order paper. Where is my motion? That determination is made by the Senate Business Committee. The Secretariat does not schedule business. The next part, which I have mistakenly set out as 10, which I believe is 11. 1 minute. Yes, 11, messages. The principal means by which the two houses communicate is through messages. If we want to, the Senate wants to communicate with a county assembly or a governor or the president, that would be also by message. So look at messages. But there's also provision for the speaker to give an advisory opinion to counties, part of the custodial role of the Senate, to bring some standardization to the business of county assemblies. There's provision for the Speaker of the Senate to give an advisory to the county assemblies. Part 12, statements, is a very important part. And please avail yourself of the opportunity provided by Part 7. Because you have an opportunity which the other house does not have. There's more airtime in the Senate, and this device of statements gives you as a senator on any day the opportunity to speak on any matter. There's our statements hour every sitting day, and you can speak on any matter of county concern, of regional concern, of international concern, of topical concern. So it will become very sad if we have to adjourn for lack of quorum, because it means that no senator wants to speak on any matter of county concern, which is the principal business, of regional concern, of international concern, of topical concern. So please avail yourself of the opportunity to do statements. You can express, it's a house of reflection. Your reflections on, I don't know, on DNA and advances in science and space exploration and regional integration and whatever it is, that is, if it is topical. But it's also the opportunity to speak to matters relating to your county, issues arising from the county. But we ask that these are of county-wide concern, not, and this is a problem we have faced, because sometimes towards particularly the end of a session, senators sometimes are eyeing a constituency for election. So we begin to have requests for statements about something that happened in a ward, or that's happening in some village, or in some location, or because of the nature of the Senate as a national chamber, we ask that statements are of county-wide concern, or national concern, or regional concern, or international concern. It's also the place where committee chairs can speak on any day about their portfolio. It's also the day when you can ask any of the chairs anything about matters in their portfolio. It's a tremendous opportunity, and sometimes there's regret in the Secretariat that not enough opportunity is utilized. of this very important device. Part 13, motions. The motion is a principal means of getting a decision by the Senate. Statements don't lead to a decision. They can lead to a decision, they can lead to an answer. You can ask and get an answer. You can convey your opinion or your position on a matter. But motions are the principal means of getting a decision. So if you want a decision, then the way to get a decision of the Senate is through a motion, and there are rules about what a motion, what can be in a motion, what cannot be in a motion. So please take time to study that. Special motions, some motions are designated as special motions because of their important constitutional nature. There are timelines when they must be disposed of. Look at what special motions are, and they must be disposed of within 14 days, otherwise they will be deemed to be withdrawn. Part 15, approval of public appointments. What's the procedure for that? We don't do many public appointments, but this could grow by statute. Inspector General of Police, commissioners of SRC, when we have some vetting by the Senate, that's part 15. Part 16, procedure for removal from state office. As you know, the Senate is the final trial court for impeachment of the president or deputy president, governor or deputy governor. This is probably the highest calling of the Senate, to preside over the removal of a president, deputy president, governor or deputy governor. So look at the procedure for that. Part 17, voting and divisions. The two different types of matters and the vote. Matters which concern counties, voting by delegation. Matters which do not concern counties, voting by the whole body of the Senate. And the Speaker is the one who decides when a matter concerns counties or does not concern counties. You have been taken through delegations, and the head of the delegation, and we will get designations for the delegation. The important part, of course, is that all bills, whenever it is a bill, all bills, the only bills in the Senate are bills concerning counties. So voting on any and all legislation is by delegations. Rules of debate, part 18, you can mix languages. For example, you address the Speaker, not the other senator. Please look through all the rules of debate. Otherwise, every time you stand to speak, you will be thrown off your feet by somebody pointing out something. You know, you are not relevant, or you are speaking on twice on a question, or you are anticipating debate, or you are speaking about a matter that's sub judice and so on, or you haven't declared an interest to a matter you are speaking to. So look at the rules of debate. That will be very useful for you. Limitation of debate, part 19. This is this rule was introduced. You can't believe it, but this rule was never there, and you could filibuster. Filibuster is endless speaking so as to wear out the other people, or just to make sure that you don't go to the next business, or you don't go to a vote because you don't have the numbers, so you filibuster. You speak and speak and speak. It's very interesting, where in legislatures, when they didn't have this rule, somebody would come and start to speak, come with a book and start to read it from page 1. Just go on, because there's no rule. You are in the course of your contribution. So someone comes with a big novel and they start to read it and read on and on, and we will not go to a vote. So that forces the side which had the numbers to negotiate, because otherwise it will never end. But now we have a rule which limits the time for debate. Then we have to go to a vote. Order in the Senate, very important, about maintaining order, no carrying firearms, standing and being silent when the Speaker is on their feet, not remaining seated during chamber, avoiding irrelevance and repetition, gross disorderly conduct, The Senate has not had a lot of trouble with disorderly conduct and senators being asked to leave. The consequences of being suspended or being asked to leave are severe, so it will be very good that you never get into the situation. So, but please look at the rules of order, maintenance of order. Part 21, public bills and the entire procedure for legislation on how that runs. That will be very important. The important thing is if you want any bill done for you, we have a legal office, write to the office of the clerk. We designate a legal counsel to help you with your idea, to make it into a proposal, and to run all the way to publication and becoming a bill. So you only need to have the idea, you ask for help, we will provide it, you have a bill to your name. Private bills, the same procedure as public bills, but we have never had a private bill in the Senate for the time we have been here. I don't know if we will have. You will have to pay for a private bill yourself. A private bill essentially is a bill which does not concern the public at large. It relates to a private matter and doesn't concern the rest of the country. And it saves you have to save the rights of the rest of the public. We haven't had any such, we probably are unlikely. Committee of the Whole, 23, the principal place where legislation is thoroughly discussed and amendments made is in Committee of the Whole. The Committee of the Whole is the principal place where amendments, where discussions on a bill are done before ultimately returning to the plenary to pass the bill. So look at the Committee of the Whole. 24, procedure on division of revenue and county allocation of revenue. Please familiarize yourself with that important part, because this is one of the most solemn duties again of the Senate, passing the division of revenue bill and the county allocation of revenue bill. Part 25, select committees, all about committees. Which are the committees? What do they deal with? How do you become, who determines members of the committees? How are they passed? What are the rules of the committees? When do they meet? Who calls meetings? Please look at the rules on select committees. Next part I want to speak about 27, public petitions, a very important role of Parliament. Public petition is supposed to be an avenue for the citizen who is aggrieved and who cannot find other remedy, other suitable remedy, or they have exhausted other suitable remedy. So they come to the legislature as the apex body expressing the sovereignty of the people and comes by prayer to the legislature to find relief. Unfortunately, it has been the experience that sometimes committees have found petitions to be a nuisance, which is a pity, because it's a constitutional right of every citizen to petition the legislature and to seek relief. So when the petitions come, petitions in our view are an important part of committee work. They enable the legislature to know what is disturbing the citizens, to investigate it, to present a report. Unfortunately, that's as far as it goes. But many times, petitions have led to action. They may embarrass the aggressor, they may embarrass government into action, they bring visibility to a matter. So petitions are really, really quite important. The one that comes most to my mind is Ouru, Ms. Kishang, what was it called? Ouru Owino. The residents of a place, I think, which was called Ouru Owino, who are suffering the effects of some toxic waste. And people are really getting really sick, and kids being born who are deformed. And that petition came to the Senate, and as a result of that, there was action and there was satisfactory relief. So petitions are very important. Part 28, journals and records and broadcast of proceedings. Everything we do in the legislature is recorded. That's why it's a house of record. Nothing is done idly. Everything that happens in committee, everything that happens on the floor is recorded, is captured in voice, is captured in audio, and the clerk is made a custodian of these records, and they are available. You can obtain access to these records. Part 29, procedure on reports from the East African Legislative Assembly and the Pan-African Parliament. That just gives the procedure for how these reports come to the House. Part 30, public access to the Senate and its committees. Generally, the general rule is that the public have access. And Senator Halwale raised that point the other day, although this is not the chamber. But generally, they have access to the Senate and its committees. But there are situations when there could be limitation to that access, and the Speaker determines in the chamber, and in committee, the committee chairperson determines when to exclude the public. It is a remedy, it's something that must be used very sparingly, because citizens have a right to know, and this is public business, not private business. Citizens have a right to know. The Constitution requires that we allow citizens access and participation in the business of Parliament and its committees. There are also general provisions in Part 31. There are provisions about when you can attend before the National Assembly, how and when you can go to a county assembly. You can go to your own county assembly according to its rules, but you cannot go to another county assembly of a county other than your own and speak there unless you are allowed by the Speaker. Provision about failure to attend sittings, 8 sittings. In the past, it used to be consecutive. But the Constitution now, it is not consecutive. It is a total of 8. Before, you needed to miss this one and the next until there were 8. Now, you miss 8 in total without Speaker's permission, and you lose. Well, there's a procedure for how to lose your seat on that account. It was actually nearly invoked in the National Assembly, and it went all the way, but somehow the member concerned did not lose their seat. So it's not an idle provision. A seat can actually be lost. Where to sit in the chamber, this already came up, I think, on the first day of sitting. You can sit anywhere in the chamber except some designated seats. Traveling outside, please note that when you travel out of the country on business or on private travel, you need to let the Speaker know, and that helps you with the loss of the seat. Because if the Speaker is aware that, and you inform them that you are away, therefore you are away with the knowledge and possibly with the approval of the Speaker. There is a new part 32 on virtual sittings. This was a consequence of the advent of the pandemic, and at some point it became the default. Virtual sitting almost became the default. But it's important to understand that virtual sittings under the standing orders are only virtual or hybrid, are only to be held where it is not possible to hold an in-person sitting. And that determination must be made by the Speaker and the Senate Business Committee. So in the foreseeable future, it is difficult to see when, if remaining as it is difficult to see when we will have a virtual or hybrid sitting. But there's provision. Then provision at 33, amendment of the standing orders. The standing orders can be amended on the initiative of a senator, or otherwise there is a periodic review of the standing orders by the Procedure and Rules Committee, which then brings a report to the Senate. So if you feel aggrieved by the standing orders, or you think there's provision for something that needs to be changed, there is recourse, because the standing orders are amenable to amendment. So I will want to end it there and just end by again commending to you a regular reading of the standing orders because they will really make you an effective legislator. Thank you very much for your time.